Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. We're getting to the end of the year, everybody, but we're not there yet. I've got 3 interesting cases for y'all this week. But before I get to them, I was asked to talk about the nonprofit Acacia Center for Justice. And as with all nonprofits helping non-citizens, I'm happy to do it. As many of us know, immigration courts do not guarantee the right to counsel for anyone, including unaccompanied children who arrive in the United States alone, often fleeing life-threatening conditions. Data confirms what common sense tells us. A child without representation in immigration court doesn't have a great chance of succeeding. To put some numbers on that, Acacia reports that unaccompanied children are 7 times more likely to receive an outcome allowing them to remain in the U.S. when they have a lawyer to defend them. So if you, legion of immigration lawyers and advocates, are interested in representing unaccompanied children, the Unaccompanied Children program at the Acacia Center for Justice is waiting for you with open arms. This program helps lawyers find jobs across the country defending children in immigration court to give them a chance at justice. Explore open roles with Acacia's 100-plus partner organizations at acaciajustice.org/defendkids. Additional links in the show notes. And now, your 3 cases for your listening pleasure. Our first case is Diaz-Valdez v. Garland, published by the First Circuit on November 22, 2024. This case is about missing BIA appellate deadlines. Not advised, but I mean it happens. Less often I imagine as everything goes electronic. This, however, is a paper case. Meaning that when Miss Diaz-Valdez lost her asylum case in immigration court, she had to mail her notice of appeal to the BIA in Falls Church, Virginia. By the way, her asylum claim was based on the fact that when she was still a teenager, gang members in Guatemala, quote, had murdered her father-in-law, twice attempted to kill her husband, and during one of those attempts, tried to run her over with a car, requiring Miss Diaz-Valdez to seek medical attention for a head injury, end quote. Anyway, the Notice of Appeal is a pretty short document, and it must be received by the BIA within 30 calendar days of an immigration judge's decision. In the wild paper world of old immigration court cases, that 30 days actually begins to run the day that the immigration court mails the decision to the non-citizen, even though in this case, as with many, it took an entire week for the non-citizen to actually receive the decision by regular mail. Non-citizens, of course, cannot afford to use regular mail and risk a 1-week mailing delay when filing their notice of appeal or other documents with the BIA, which is why we always use overnight FedEx delivery with tracking. Or if you're really in a bind, Ben Winograd's same-day filing service. Ms. Diaz-Valdez did indeed use FedEx overnight delivery. Guaranteed delivery, actually. Would have worked, but FedEx did not hold up its end of the bargain, and ended up delaying the actual service, making the notice of appeal 1 day late. Part of the reason might have been that it was a federal holiday weekend that immediately preceded the filing deadline. I don't know. Big problem, though, because under the BIA's own regulation at 8 CFR section 1003.38c, a filing is timely when received, not when mailed. Quote, given its filing rules, the BIA advises non-citizens to, whenever possible, use overnight delivery couriers, such as Federal Express, United Parcel Service, DHL, etc., to ensure timely receipt, end quote. That's from the BIA's practice manual itself. Which again, Ms. Diaz-Valdez did here. Her case is actually even more sympathetic. Like I said, she mailed it using FedEx guaranteed next day delivery on September 4th, so she claimed, trying to meet her September 7th deadline. September 5th and 6th were weekend and holidays, but still, that should be more than enough time for FedEx to get its guaranteed delivery to the BIA. It was not. It was delivered on September 8th, 4 days after it was mailed, and 1 day late. So, the BIA dismissed the appeal. When Ms. Diaz-Valdez explained all of this in a quickly filed and robustly evidentiarily supported motion to reconsider, it seems, the BIA held that Ms. Diaz-Valdez had waited too long and also had not sufficiently supported her claim that she had sent the FedEx on September 4th. Really just an absolute nightmare scenario for counsel. The First Circuit remanded. Because to the court, it came down primarily to whether the BIA was wrong to find that Ms. Diaz-Valdez's case didn't warrant equitable tolling of that filing deadline. And that is a mixed question of law and fact that the circuit reviews de novo, explained the First Circuit, relying on Supreme Court and other circuit precedent. You always, of course, want to be in de novo land when petitioning for review, and it won the day here. Didn't hurt, of course, that the BIA itself said that its 30-day notice of appeal deadline is not jurisdictional and is instead a claims processing rule subject to equitable tolling in matter of Morales, episode 158. Equitable tolling is always a two-part test. The party that wants equitable tolling must show that she, quote, has been pursuing her rights diligently and that an extraordinary circumstance nevertheless prevented timely filing, end quote. Diligence doesn't mean, quote, maximum feasible diligence, end quote. Rather, it means, quote, reasonable diligence, end quote. Considering all of this, the BIA erred here when it simply brushed aside counsel's statements about the mailing of the notice of appeal on September 4th. Along with brushing aside other evidence and ignoring it, including the FedEx label itself, that instructed that FedEx was to deliver the notice of appeal on the weekend. Quote, importantly, an attorney's representation to a court that they sent a filing on a certain date is generally accepted as sufficient to establish the date of mailing. Courts around the country routinely rely on such representations, end quote. Preach, First Circuit. Preach, I say. String cited too with cases from other circuits throughout this great land. I don't even think it has to be in an affidavit, but that's probably good practice. And be ethical with this awesome power, counsels, because you're subject to sanctions if you misrepresent, notes the First Circuit. Again, the court also sees other non-testimonial evidence supporting a September 4th mailing here. That included, but was not limited to, that weekend delivery instruction that I mentioned, and the label itself indicating that it was created before the close of business on September 4th at 3:42 p.m. By the way, don't sleep on the implicit holding here that mailing a notice of appeal just before the weekend and 3 days before a deadline is sufficiently diligent. And that's because, after all, citing Ninth Circuit precedent, non-citizens are entitled to that 30 days or near 30 days to weigh the costs and benefits of appealing. So, to the court, diligence showed sufficiently for a remand for further analysis from the BIA. As to extraordinary circumstances, the second prong for equitable tolling, it was sufficient for a remand to, quote, a party can satisfy the extraordinary circumstances requirement by showing that reasonable expectations about an event's occurrence were interrupted and that the interruption was both extraordinary and beyond the party's control, end quote. Neglect and attorney miscalculation won't usually cut it. But using guaranteed delivery service that, quote, fails to fulfill its guarantee, end quote? Well, that's straight out of Morales, sanctioned by the BIA as extraordinary, it would appear. Probably why the BIA in this case seems to have focused heavily on a perceived factual dispute surrounding diligence to deny. But yes, indeed, the BIA found extraordinary circumstances lacking in this case as well, and in so holding to the First Circuit, completely ignored its own apparent blessing of guaranteed delivery services that are then interrupted from Morales. Can't do that. Explain the First Circuit. So case remanded, after what was clearly a very well-argued petition for review. Meaning, congratulations Christian R. Meyer and Kevin P. McMurray for petitioner, along with Mary Hulper, Cassandra Harris, and Deepti Selapan, for a group of primarily law school amici, which included none other than the Immigration Clinical Program from my alma mater, Boston University School of Law. Go Terriers. One observation worth observing. Worth noting and worth reiterating. The First Circuit just held that equitable tolling, again, is a mixed question of law and fact that is therefore reviewed de novo. Makes sense, too. The Supreme Court said as much in Guerrero Aspria v. Barr. And as a mixed question of law and fact, this would be the case presumably no matter the context that an equitable tolling argument is being made, such as in a motion to reopen, and no matter whether it's the BIA or the circuit reviewing denial of equitable tolling, would still be reviewed de novo, it would seem. Pretty good for appellate attorneys representing non-citizens. And that is Diaz-Valdez v. Garland. We continue with matter of Larios-Gutierrez de Pablo and Pablo-Larios, published by the BIA. We are hopefully concluding our deficient notice to appear saga, nay, the journey I have been blessed to take you all on these last 4.5 years. This case is primarily about matter of Fernandes. Recall in that decision, the BIA finally came around to say that immigration judges have to deal with the mandatory claims processing rule violation that is DHS's failure to include the date, time, or location of a first hearing in a notice to appear. But only if timely raised, said the BIA. It seemed to me and others at the time that as a remedy, only termination of proceedings would do. But recently, in matter of RTP, for example, the BIA said that actually, IJs can just fix the NTA themselves on DHS's motion by writing it in the notice to appear, which is weird and surely will be challenged. Anyway, this case is about matter of Fernandes. The respondents here, a mother and a child, conceded proper service of the NTA through counsel at their first hearing, and didn't object to DHS's failure to include everything required of an NTA in the NTA until 5 years later, in October 2022. At that point, the respondents moved to terminate. The IJ granted the motion and terminated proceedings. It kind of seems, at least implicitly, that the IJ held that the objection to the NTA was untimely, likely meaning under matter of Fernandes that the respondents had waived the objection. And matter of Fernandes had been published by the point that the IJ ruled. Per Fernandes, timely means, quote, generally, raised prior to the closing of pleadings before the immigration judge, end quote. So I guess not always or exclusively, right? Generally. But anyway, the IJ here held that matter of Fernandes can't apply retroactively to defective NTAs that, I suppose, initiate removal proceedings pre-matter of Fernandes. Complicated stuff, and DHS appealed. The BIA disagreed with the immigration judge. It held here that matter of Fernandes is not a change in law, so it can be applied retroactively. 8.5 more pages single-spaced to make that holding, so let's go. Some of it just rehashes the history of all this, which I kind of just did and which I've done to death on the podcast, so I will largely skip it. To be honest, the retroactivity stuff is more interesting to me, as it of course applies to other precedential BIA decisions as well, and not simply in the deficient NTA context. While the BIA believes that its new precedential decisions should generally apply retroactively, quote, there are times when agency decisions announce new rules that change the law in a substantial way, and it may be unfair to apply the new rule retroactively, end quote. To the BIA, quote, a published BIA decision that interprets a previously unclear statute, for example, does not constitute a change in law for retroactivity purposes, end quote. Rather, under its 2019 precedent matter of Cordero-Garcia, the proper question for retroactivity is whether the new decision, quote, consciously overrules or otherwise alters its own rule or regulation, or expressly considers and openly departs from a circuit court decision, end quote. So like matter of Diaz-Lizarraga and the change of the CIMT definition for theft-type crimes, that would totally not be retroactive, right, BIA? Why haven't you just said it yet? I digress. Matter of Fernandes is not a case, said the BIA panel. It didn't really break new ground in deeming a deficient NTA a claims processing rule violation, or in requiring assertion of claims processing rules to be timely. Circuits had already said it, and the claims processing rule framework relied on well-established Supreme Court precedent in other situations, explains the BIA. To the extent that matter of Fernandes really firmed up the timeliness requirement, it merely, quote, clarified the law by resolving an issue about which there was no clear guidance, end quote. When the BIA does something like that, explains the BIA, relying on the Supreme Court's old Chenery decision, retroactivity concerns are not implicated. Not for nothing, explains the BIA in a few pages, the circuits also seem to agree that untimely challenges to deficient NTAs can be, and almost always are, waived. To put a stamp on it, the BIA explains that INA Section 239A1, quote, is and always has been a claims processing rule, end quote. So no new ground was broken with Fernandes. But come on, BIA, be honest. You didn't know what a claims processing rule was until the circuit started telling us. Heck, I'm not sure that they even knew. And of course, everyone was cool with deficient NTAs before Pereira. To the extent other BIA decisions might have supported a different timeliness analysis in the past, it was passing dicta, explains the BIA. Now it's true that the, quote, Supreme Court has held that a litigant's failure to raise an issue in a timely manner may be excused if the issue was truly novel, and there was no reasonable basis in existing law for raising the issue, end quote. Seems like a dang good quote for arguing about other issues when the law changes again in the future in another context. And that's Reed v. Ross from the Supreme Court, 1984. But matter of Fernandes, not such a case, explained the BIA. The respondents could have made the argument, that is, that proceedings should be terminated because the NTA was deficient, even if it wouldn't have succeeded at the time. That, quote, does not excuse the lack of a timely objection to the notice to appear, end quote. So counsels, if you needed an excuse to make all the arguments that might come to your mind, here it is. Don't hold back. Future you will thank you. In conclusion, then, the BIA held that it didn't even need to conduct the multi-factored retroactivity analysis from matter of Cordero-Garcia. Fernandez' timeliness requirement wasn't a change in law. Issue closed. Having so held, the BIA held that the IJ erred in concluding that the respondent's motion was timely. So I guess it wasn't an implicit untimely holding by the IJ. My bad. First, explained the BIA, the IJ was wrong to rely on the sea change that was Pereira and Chavez from the Supreme Court. Those cases were about the stop time rule, not about terminating proceedings, explains the BIA. Also, quote, while the Supreme Court's decisions in Pereira and Chavez may have resulted in arguments regarding jurisdiction and claims processing rules, the text of INA Section 239A1GI has remained unchanged and was plain on its face long before those decisions were issued, end quote. Come on, guys, come on. I'm not even attacking the holding about retroactivity here, but that quote, come on. More persuasively to me, the respondent's motion was filed 18 months after Chavez, and all of these arguments were being made well before Chavez, after Pereira was issued. Other arguments summarily rejected, and the case was remanded for further proceedings. Gotta object to deficient NTAs before the close of pleadings, everyone. Beware. Wonkiest of observations before leaving the case. In a footnote, the BIA addresses something that I've actually kind of always wondered about. See, INA Section 239A1G actually only requires that the time and place of the first hearing be included in the NTA. Nothing about date, but that makes absolutely no sense. As such, the BIA, quote, construes time as including the date of the hearing, end quote. So there you go. Thanks for being practical, BIA. And that is a matter of Larios-Gutierrez de Pablo and Pablo-Larios. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. Meaning we conclude with USA v. Minor, published by the Fifth Circuit on November 20th, 2024. Gonna do this Fifth Circuit remand in the sentence enhancement context a bit unorthodoxically, making up words this week. In this decision, there were a few holdings specific to the federal criminal sentence enhancement context that you need not concern yourselves with, listeners. But what you should concern yourself with is the main reason for the remand here. Applying the categorical approach, the Fifth Circuit held that a federal marijuana conviction that criminalizes possession or use of hemp does not match the Controlled Substance Act's federal definition of marijuana as of 2018, when the Department of Agriculture removed hemp from the marijuana definition. It's confusing stuff, the categorical approach always is. Mr. Minor, not a minor, had convictions for lots of drug stuff, but the federal court enhanced his sentence for that even more because of prior federal marijuana convictions from 2000 and 2010. At the time of those convictions, the definition of marijuana that he was convicted under included criminalization of hemp, but no longer. By the time that the district court judge relied on those prior convictions to enhance his 2022 federal convictions for other stuff, the federal government had removed hemp from the marijuana definition, again in 2018. As such, the district court erred, explained the Fifth Circuit, because that meant that by the time of the enhancement, under the categorical approach, the definition of marijuana in the prior offenses did not match the CSA's definition of marijuana used for sentence enhancement. And well, to me, that seems like a pretty big deal holding. For those who practice criminal law or who are very wonky with the categorical approach, the Fifth Circuit also distinguished the Supreme Court's holding in Brown v. United States from Episode 213, which concerned the time of drug comparison in the Armed Career Criminal Act context. In Brown, the Supreme Court held that in the ACCA context, you compare the CSA drug definition at the time of conviction to the definition of the drug at the time of conviction, if I recall. But in Brown, the Supreme Court mentioned that its holding didn't necessarily extend to career offender sentence enhancement analysis. That's what's at play here, and it's another separate, albeit similar way to increase the imprisonment sentence of a convicted individual in federal court. In this case, the Fifth Circuit is holding that in the sentence enhancement context, non-armed career criminal act, you compare the definition of the prior criminal offense at the time of the conviction to the definition of the CSA at play at the time of enhancement. But not to worry, my immigration friends, most of you need not concern yourself with such trivialities. What's important here again is that if you're applying the definition of a federal or state marijuana offense at the time of conviction to the definition of marijuana in the Controlled Substance Act today, which I believe is the analysis used in immigration, the federal or state marijuana conviction from years past will be broader than the federal marijuana CSA definition in effect today, if the state or federal definition permits conviction for doing stuff with hemp. Again, seems like kind of a big deal. Now, very wonky and in-the-weeds Fifth Circuit practitioners might be saying, wait a minute, Kevin. We have this weird realistic probability requirement mandating that practitioners find an overbroad prosecution case to make such arguments. So if, for example, this was a Texas state marijuana conviction and Texas technically criminalized possession of hemp, you'd need to find a case of actual prosecution in Texas to potentially win on this argument. Not the case in all or almost all other circuits, but yes, the case in the Fifth Circuit. The panel explains here, however, that Mr. Minor's situation is a bit different. His predicate convictions were federal marijuana convictions, which of course are governed by the CSA. But the CSA federal definition of marijuana changed in between those convictions and his later convictions that are now being enhanced. And in the Fifth Circuit, when you're comparing a federal conviction to the federal enhancement definition, application of the realistic probability test, quote, does not apply, end quote. Footnote 9. And that's pretty fascinating. Bet it's the same in immigration too. I bet you'd be successful in the Fifth Circuit arguing that you need not satisfy the realistic probability test with a textually overbroad federal statute of conviction as compared to the removable offense. Or restated in non-legalese, I bet federal marijuana convictions pre-2018 don't make a green card holder removable today in the Fifth Circuit or anywhere. And that's just the bare bones minimum lesson to be gleaned from this interesting case, in my humble opinion. Isn't crimmigration a trip? By the way, Mr. Minor's case got remanded for resentencing. And that is USA v. Minor. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.